Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. All right. I'm back, you guys. I know it's been such a long time since I did a live stream. It may have actually been the charity stream, come to think of it. That may have been the last time that I actually did a normal live stream. Everything else lately has been pre-recorded, and that's because I've had a few things going on. I'm sure most of you probably know, but basically immediately after the marathon that was the Depp v. Heard trial, covering all of that for basically 2 months, I immediately jumped off that treadmill and then dove headfirst into a treadmill of sprints towards a wedding day. Mr. Bites and I have been married for over 2 years, legally on paper, but we always wanted to have that sort of traditional big wedding, so to speak. Very common in military families, military marriages, where people will, the guy will propose and, they'll get married very quickly so that you're recognized by the military, so to speak. And then also other good reasons to go along with that. But then a lot of people still want to have their big day. And so that was that for us. It was beautiful. Had a lot of friends from around YouTube and from, LawTube, Justice for Johnny Depp community. Nate DeBruin was there with us. It was great. We had a really great time. And of course, a bunch of other family and friends from outside of this wonderful internet space that we are in. I see in the chat, lovely nails, Mrs. Bites. Thank you. I know this is my first time actually getting any kind of acrylic nails. I grew up playing the violin. So every single violin teacher that I had would look at this with horror because they would be like, you need to cut your claws. I don't know if I would get acrylics again, though, to be honest, because I'm so used to being able to type and I don't know. I don't really play the violin as much as I used to, but actually I haven't picked it up in a long time. But I'm so used to having more dexterity than I feel like I can have right now with very long nails. But anyway, they look pretty, so it's nice. I'm not going to complain about it. But anyhow, so yeah, it's been a very eventful, you could even say it's been an eventful 3 months, really, given everything that has happened. And of course, and Andy the Game Maker says your wedding reception MC was god awful. Fire him. He says that because he was the MC himself. Thanks, Andy. Thanks for the super chat, and thanks for being the MC. You were very funny. You had some rave reviews. It was good. And T in Tennessee says hello. Thank you so much for your super chat. I appreciate that. And I think there was another. Oh, we have a new member here. Average Rando. Thanks for becoming a YouTube member. That's awesome. So, so we've got some stuff to talk about today. We have a few things to talk about. And some of this, I'm sure, or maybe a lot of this for a lot of you is probably going to be some review, because I know a lot of people have talked about the motion to set aside the verdict. I'm going to give a lot of that kind of quick treatments because I know people have talked about all of this stuff, and I don't want to, beat a dead horse, so to speak. I know that's kind of a violent metaphor, but you know what I mean. Like I don't want to drag things on for much longer than really needs to, but I do feel like I kind of want to talk about some of this stuff, especially because since that original motion, there's been that supplement, and now we've got some some subtle shade from Ben Chu in response to that. So we've got some good stuff there. Plus, of course, there's the New York Marine versus Amber Heard lawsuit. There's a complaint there that we can go over, and there's been a settlement in the Gregg Brooks v. Johnny Depp case. We had been hearing from some murmurs here and there that was possible, and that was always going to be possible. It was. I mean, I have settled cases that I've said this before. The closest that I have gotten to sitting in first or second chair in trial, other than playing, kind of a background role in trial, was a case that literally settled the moment that I got all of the banker's boxes in the courtroom for all of the evidence and all of our binders and all of our stuff that we needed for trial. The partner turned to me and was like, "Hey, we're settling." So it is entirely possible that you could have a settlement happen going right up to basically the moment where the judge turns to the attorneys on both sides and says, "Are you ready to begin?" So anyhow, but so we'll talk a little bit more about that. But I think first we should maybe go in some chronological order while we to go through the motion to set aside the verdict. So let's see here. And I did not order this properly from what I wanted to do. Here we go. Share screen. And it's going to be this. Oh, and I'm getting a text that my mic sounds weird. Folks in the chat, let me know. Does my mic sound weird to you? It is on. It's all plugged in. Should be fine. Let me know. I know it's going to be like a 10-second delay because there's a delay on getting. No. Okay. So things are fine so far. Good for me. Okay. Sounds normal for me. Okay. A little echo. That's all. Okay. Okay. Sounds good. All right. So then I will disregard then. Okay, good. Just wanted to double check before we get into it. Okay, so I'm basically, for the original motion, I'm going to go through, is this better? Oh, no, that's too big. Okay, I'm just going to go through the basic outline because most of this is, Secret Rick Squirrel, this is because they're not used to your voice anymore. Well, this is somebody who has heard quite a bit of me over the last few weeks, so I would think that this person that texted me, anyway. Anyhow, okay, but that's funny. That's very funny. Okay, let's get into it. I'm gonna mostly ignore the chat at this point, and go through this because and like I said, I'm just gonna go through the basic outline without getting into 53 pages of this motion that probably, I mean, I want to say this motion that shouldn't be here because I would expect them to file a motion like this because they're the losing side, and that is just so common for what happens in these kinds of cases that it's almost a matter of course. Basically, is my main point. So okay, anyway. First argument that they had, so they had this whole motion, as most people know, they have this whole long motion talking about all these reasons why they want to either dismiss the complaint, investigate improper juror service. They want to set aside the verdict on all three counts of plaintiff and counterclaim defendant John C. Depp's complaint. So basically what they want to do is they want to say, okay, all of these times that they found that Amber Heard was liable for defamation against Johnny Depp, they want to set aside the verdict, either dismiss it entirely or at the very least give her a chance for a new trial. This is basically what they want to say. And these are all the reasons why. So the first reason is the damages awarded by the jury are unsupported by the evidence in the law. They want to try to say that there's no evidence of pecuniary damages from the op-ed, basically saying that there is nothing that they introduced at trial. It's none. Not saying here that the evidence is not good enough. They're saying that the evidence that there is none of any kind of monetary damages from the op-ed, and that is simply not true. They introduced a lot of that. They had expert witnesses. They talked about the money that he was making in 2017 versus 2018 versus 2019. There was all of that. So there was a heck of a lot of evidence. Definitely not none. There was definitely a lot, and it was reasonable to it was very reasonable to reach that conclusion. The jury, and then next they say the jury's compensatory and punitive damages were excessive as a matter of law. No, they weren't, because there was plenty of evidence to show that he was entitled to that kind of compensatory and punitive damages. If the punitive damages, if the judge had, let's say, not limited the punitive damages from $5 million down to $350,000, there's an argument for that, but she did, as is a matter of course for under the statute, under the local statutory requirements in Virginia. So he got the maximum because that was as much as he could get, because what the jury awarded him was way above that maximum. So I mean, I described it this way before. You have the compensatory bucket, and then you have the punitive bucket, and think of them as like water, right? Because you can only fill a bucket up to a certain point with water. Everything above that is going to flow out. So in terms of that punitive bucket, that only fits $350,000 of damages. Anything above that, a single penny above that, it spills out. So that's the max that he can get. Even though the jury obviously wanted to give him more than that. Then they say Mr. Depp is not entitled to damages for any conduct prior to the op-ed. Sure, that's true, but the jury instructions showed that the instructions that they were given was they said that the damages that you are awarding is starting from the date of the op-ed. So it doesn't get more clear than that. That's what they were instructed to do, and so you can't just assume that they didn't follow those instructions. I mean, you, at the very least, would have to have some kind of evidence showing that they didn't follow those instructions, and even then, I don't know. You'd have to have a pretty damn good argument. All right. So then they say Mr. Depp is not entitled to damages for alternative causes, including the Sun publication, the ensuing litigation brought by Mr. Depp, the UK trial and surrounding publicity, and the UK judgment. Sure. Again, same thing. Same reason as before. The jury was given the jury instructions, and they were very clear on that. Virginia case law supports setting aside damages judgments that are excessive. Well, these are not excessive. So, then they try to go into the verdicts on the complaint and counterclaim are inconsistent, therefore should be set aside. No, all you need is a reasonable explanation for why they would decide one way on one of the statements and another way on another. And I think, it took us all a beat to kind of figure that out. It took us like a minute. If you remember, if you watched the verdict on this channel, you might remember that all of us on the panel were kind of like, that's interesting. That's a little strange. But then it took us a little bit of conversation to realize, like, okay, so what happened was the jury found that the general statements that Amber Heard says are defamatory, the general statements about the hoax claim, the jury didn't find that to be the jury didn't find that to be defamatory. It was where you get more specific that the jury said, okay, well, I don't know. That sounds defamatory to me. And that's fine. That's a perfectly reasonable explanation. And so where there is a perfectly reasonable explanation and there's evidence to support it, the judge isn't just going to overturn a jury verdict if there's a reasonable explanation like that. Next, they say the First Amendment bars recovery for defamation by implication when the statements at issue are true on their face and involve a public figure or matters of public concern. Okay, so first off, in order for this to be the case, this situation has to be one where the issues are the statements at issue are true on their face and they involve a public figure or matters of public concern. It's not or, right? So it's not enough that it's just involving a public figure or a matter of public concern. So the fact that it's Johnny Depp and he's a public figure is not enough on its own to say that he is not allowed to recover for defamation by implication. There has to be this added requirement, which is that the statements at issue are true on their face. And the jury verdict, once again, we can go to the jury instructions where it specifically asks them, did you find that statement was a lie? If the jury found that was a lie, then it's not true on its face. So, okay. We're gonna go through that one too. Next one is the jury's finding of defamation by implication with respect to the op-ed headline statement is contrary to the law and unsupported by the facts. And then they go through in detail here. So okay. So they say there's no support. One of their sub arguments is that there's no support for the conclusion that Miss Heard initially made or published the headline. The newspaper had added the headline, and Miss Heard played no role in the authoring or publication of the headline statement. So it doesn't have to be. That's not a requirement. So it's not a requirement that they have to show that she actually wrote the headline. It is enough to show if she republished it. And that goes to be there. Miss Heard's tweet linking the newspaper article does not constitute republication under applicable law and the facts. It does. It does. There is enough there. If an argument could have been made if she just had the link in a tweet and that was it, but she added language to it that showed that she was taking ownership of that entire article, including the title. So yeah, that's going through that very quickly. Mr. Depp did not present evidence of actual malice. See, this is an argument that can be successful if the defendant that we're talking about is a third party. So for example, if this were against the Washington Post as opposed to against Amber Heard, this argument about presenting evidence of actual malice could be successful, because when you have somebody that is potentially liable for making a statement that they made about another person based on information that they were given from another person, they still have to show when the plaintiff in that case is a public figure, they have to show actual malice, as of course we know. But the difference here is where it's something like a publication, they're relying on information given to them by someone else. That could be negligence. That could just be that they had they had a general idea based on the fact that she came to them and said, this is what happened to me. That's a fairly reasonable thing to rely on. If you have a public figure that comes up to you and says, this happened to me, let's write about it. And they say, okay, you seem to be a fairly credible source. It's different when that false statement is coming from the individual themselves. In other words, when you have Amber Heard making a statement in the Washington Post and you show that she's the one that actually made the statement, if you can show that she lied about that she lied in making that statement, actual malice is almost just implied, because how could that be anything less than intentional, right? If she knows what happened to herself, she knows, right? She knows whether there was DV or whether there wasn't. So, actual malice can be shown based on the circumstantial evidence. The fact that this is someone who was an intimate partner of Johnny Depp herself, and she says, this is what happened to me. So, okay. Anyway, so that's the bit about actual malice. Very, again, relatively easy to kind of blow past that one as well. Next is Mr. Depp did not present sufficient evidence to support a finding of defamation by innuendo. They say that no evidence surrounding the op-ed's publication would reasonably cause a reader to believe the title of the online edition is about Mr. Depp. I don't think that's true, because any reader of the op-ed, any reader of the headline is not going to look at it in a vacuum, right? They're not going to look at it and say, oh, hey, I see this title of this op-ed and it's different from the body of the op-ed. If you are suggesting that you were talking about someone and you don't make certain things clear throughout, you run the risk of those statements that are suggesting that you're talking about a certain person. You run the risk of those all bleeding together, right? Because a reasonable person is going to read all of that together and say, oh, okay, you're trying not to name someone, but I can tell that you're naming someone because you're talking about something that happened to you 2 years ago. Let's look back at the calendar to 2 years ago. Oh yeah, right. That was the TRO hearing. Okay. So that is completely reasonable. And it doesn't take a lot to argue that against a motion like this. Like it has to be, in order for them to win on these kinds of arguments, like it has to be the kind of thing where it's like it is literally impossible for the jury to conclude the way that they did. Because if there's any just like what we were looking at throughout the trial, when they were trying to dismiss various claims throughout trial, and Judge Azcarate said, if there is a scintilla of evidence, a chinchilla of evidence, that is enough for this claim to survive, because we want the jury to hear as many claims as possible. Judges don't like taking decisions away from the jury, whether it's leading up to the jury verdict or after the jury verdict has been rendered. So judges don't like taking that away from them. So in order for Heard's team to win on any of these arguments that we've gone over, that we're going over right now, on any of these arguments, the Amber Heard team has to be super tight in all of these arguments. And so far, there's for every single argument that they've kind of lazily lobbed over the net, it's very easy to respond with another lazy lob to send it back over. It doesn't take a lot, in other words. So, yeah. Okay. Moving on to the next argument, that they say no evidence established contemporaneous facts surrounding the publication of the op-ed that would reasonably cause a reader to understand any of the statements as conveying a defamatory implication about Mr. Depp. No, that's not true. There was evidence. Of course there was evidence. Contemporaneous facts surrounding the publication of the op-ed that would reasonably cause a reader. No, of course. There was, I mean, if they're talking about the headline, there's her republishing tweet and the contents, the substantive contents of her tweet, that she herself put in there, to get this, the link to this op-ed out on Twitter through her profile. So there's that. And then there's also just the context of any reasonable reader that is reading this op-ed in the online version or the print version, doesn't matter which one. Like I said, the reasonable reader doesn't read any kind of a newspaper article within a vacuum, right? All of it is context for the rest of it. And then they say Mr. Depp cannot recover for statements Ms. Heard made during judicial proceedings, that he failed to prove that any statement in the op-ed implies he abused Ms. Heard. That would be true, but the statements at issue were not statements that were made in any judicial proceedings. Even if those statements were also made in judicial proceedings, that's not enough to protect those statements from all liability anywhere. If she just repeats it elsewhere, then sorry, let me just saving a thought for a minute before it escapes me. But the fact, like I said, the fact that a statement was also made during a judicial proceeding doesn't protect it outside of that proceeding if it's made elsewhere. Case in point, their entire case against Johnny Depp for Adam Waldman's statements, right? Because all of those statements that he made to the press were all legal arguments for what Johnny Depp was saying, what Johnny Depp, the Johnny Depp's case. Those were all arguments that Adam Waldman was making on Johnny Depp's behalf in the context of the litigation, of this particular litigation that was already active. So if they're going to try to say that just because a statement was made also in a judicial proceeding, that it's also then protected everywhere else. That's not true. That's just not true. Then they say the court should conduct an investigation of juror number 15 and whether jury service was proper and due process was protected. And so we will be going through that. And so we have a special request from in the chat. Someone asked to look at the footnote on page 41. Let's go over it. Why not? Just for funsies. Let's talk about it. Yeah, I remember seeing this. Okay, here we go. Now, footnote 9 says Ms. Heard recognizes that Virginia Code Section 8.01-353 states that any error in the information shown on the jury panel shall not be grounds for a mistrial or assignable as error on appeal, and the parties in the case shall be responsible for verifying the accuracy of such information. But the apparent error in the jury information form relating to Juror 15 is not the basis for Ms. Heard's concerns. It is the potential, by the way, keep that in mind. It is a potential that Juror 15 was not, in fact, the same individual that the court assigned as Juror 15 and or was not verified by the court clerk's office as required by Virginia Code Section 8.01-353.1. This would warrant setting aside the verdict and ordering a new trial. We're gonna get into this juror number 15. This is like a perfect swan dive right into what I wanted to talk about next, which is the supplement that Amber Heard's team filed subsequent to this motion. And we're going to talk about this section. We're going to talk about some case law on this section as well. So let's put a little pin in that little footnote there. And let's get into this next one. Supplemental memorandum in support of Section 7 of defendant and counterclaim plaintiff Amber Heard's post-trial motions based on additional discovered facts. This is so just a side note on this kind of a supplement to a motion. I have had bosses who would be absolutely livid if my colleagues and I started filing like supplemental briefs like this to a motion that was long filed a while ago. And by the way, hey everyone coming over from Emily D. Baker's chat. Welcome. We are talking about the Amber Heard series of motions, series of filings regarding the motion to set aside the verdict. I'm getting a little bit caught up since I've been away for a little bit. So just for a little bit of context here. We're now looking at the supplemental one, and I'm just about to get into it. But before I get into all of the substance there, it's just bad form. It's just bad form to be filing like multiple, like, oh, oops, we forgot this. Oops, we forgot this. We need to update this. Even if technically like it's not something that's going to be malpractice or anything like that, it just looks like the right hand doesn't know what the left hand is doing at the firm, so to speak. So it's, I would have had bosses that would have been incredibly upset about seeing these kinds of filings, being like, really, we can't just get this all in one fell swoop, and especially considering the actual substance of the supplemental memorandum. And let's go into it. So. Supplemental memorandum in support. Let's go through it. This one's much shorter, so we're going to go through the actual substance of it. Defendant and counterclaim plaintiff Amber Laura Heard, Ms. Heard, hereby supplements Section 7 of her post-trial motion based on newly discovered facts and information that juror number 15 was not the individual summoned for jury duty on April 11th, 2022, and therefore was not part of the jury panel and could not have properly served on the jury at this trial. Therefore, a mistrial should be declared and a new trial ordered. Okay, sounds pretty damning, but is it really? let's continue on. Virginia law provides that only those jurors whose names appear in the list provided for under sections 8.01-348 and 8.01-351 shall be used for the trial of cases, civil and criminal, to be tried during the term. Virginia, and then it cites to code 8.01-355. Fairfax County explains that these potential jurors are selected from the list of registered voters in Fairfax County. Where it says every year citizens' names are randomly selected by the Virginia Supreme Court from the list of registered voters for the Fairfax area. And then they cite to the answer book for jury service, which says potential jurors are selected randomly by the jury commissioners using lists designated by the courts, such as the voter registration list and the driver's license list. Now, one thought before we continue on with more substantive legal analysis is the two individuals, assuming that there are two individuals here, like assuming that they're correct about this juror 15 thing, and that there is, you know, a senior and a junior, you know, that are within the same household or something along those lines. First off, do we know that both of them, that one of them is ineligible? Do we even know that at this point? That's not clear to me, because it could very well be that they are both on the same list and could have been randomly selected. In which case, where's the error? Like, where's the harm, right? So the fact that this starts off as a randomized process, and then of course it doesn't stay as a randomized process. There's already kind of sort of shaky ground, you could say, for Amber Heard's side here. But let's read on. It says, in this case, the jury panel list included an individual named blank, which they've redacted, of course, with a listed date of birth of blank, 1945, residing in blank, Virginia. This means the individual would have been 77 years old at the time of trial. The attached voter registration information lists two individuals with a last name residing in the same place. And they said they've got them date of birth, 1945, 1970, same person listed on the jury panel list. So both of these individuals apparently live at the same address. The individual who appeared for jury duty with this name was obviously the younger one. Thus, the 52-year-old sitting on the jury for 6 weeks was never summoned for jury duty on April 11th and did not appear in the list as required under Virginia Code 8.01-355. Okay. They could still be a person that could have been properly called at random on the list. I don't know, right? So, but reading on, as the court no doubt agrees, it is deeply troubling for an individual not summoned for the jury duty, nonetheless, to appear for jury duty and serve on a jury, especially in a case such as this. This is a high-profile case where the fact and date of the jury trial were highly publicized prior to and after the issuance of the juror summonses. Virginia has in place statutory code provisions designed to ensure the person called for jury duty is the person arriving for jury duty. See Virginia Code, Section 8.01-353.1, requiring verification by the court of an individual's identity before jury service. Fairfax County's juror questionnaire webpage furthers this goal by requiring all county residents to log in using their 7-digit juror number, zip code, and birth date in all in italics and bold. Those safeguards are in place and relied upon by the parties to verify the identity of the correct juror to ensure due process and a fair trial for all litigants. When these safeguards are circumvented or not followed, as appears to be the case here, the right to a jury trial and due process are undermined and compromised. Ms. Heard had a right to rely on the basic protection as prescribed by the Virginia Code that the jurors in this trial would be individuals who were actually summoned for jury duty. In this case, it appears that juror number 15 was not, in fact, the same individual as listed on the jury panel. Ms. Heard's due process was therefore compromised. Under the circumstances, a mistrial should be declared and a new trial ordered. All right. Conclusion For all the reasons set forth above and in the initial memorandum, Ms. Heard respectfully requests this court declare a mistrial due to improper juror service in violation of her due process rights and order a new trial and such other action or relief as may be appropriate. And, oh, I missed this footnote right here. Okay, footnote 1 says, Mr. Depp would be incorrect in contending Ms. Heard somehow waived this argument by not raising it during voir dire. Not only were the voir dire questions ruled on in advance and the parties limited to those questions during voir dire, but the responsibility to ensure that the potential jurors participating in voir dire are the ones listed on the jury panel rests with those individuals and the court. Due process entitles litigants such as Ms. Heard to rely on the basic assurance that potential jurors who are who they say they are and are the actual individuals the court summoned. Okay, we're going to get to the obviousness of the fact that this is the wrong person because I'm sure many of you, I've seen it in the chat. You guys are like, just wait until you see Ben Chu's response. Yeah, we're gonna get to that in just a second because there is a very strong argument for a waiver in this particular issue because of the fact that, you know, okay, they're saying we weren't able to choose the questions that we got to ask, right? They're like, all of those questions were picked out ahead of time. They have the ability to object. They have the ability to strike. They have the ability to say something to the judge about the fact that something feels off, something feels fishy. So where they have the ability to object, they have also a responsibility to object in a timely manner. Objections always in trial are waived if they are not made in a timely manner. So, and this is something that is an explicit obligation. So, this little ditty about, oh, well, you know, we didn't actually waive it, but like Depp's going to say that we waived it, but we didn't actually waive it because, you know, we didn't have a chance to ask the questions that we really wanted to ask. Sorry, that's not a good enough excuse. It's just not. So let's see what Johnny Depp's side has to say about this. All right, let's pull this up. Okay. Plaintiff's motion to strike defendant's out of time supplemental memorandum in support of her post-trial motions. Out of time. We are talking about Back to the Future here, guys. Back to the Future, out of time. We are right there with the Milani makeup packet where she's going back in time and wishing that she could do something different. Let's get into it. Plaintiff John C. Depp II, by and through his undersigned counsel, hereby moves this honorable court to strike defendant's supplemental memorandum in support of her post-trial motions, stating as follows. Argument. And there's, 3 points here, I think. Yes, 3 points. First point, defendant Heard's filing is untimely. Pursuant to the court's direction, Ms. Heard's deadline for submitting her post-trial motions fell on July 1st, 2022, 1 full month after the jury rendered its verdicts. It is undisputed that Ms. Heard did not file her supplemental memorandum until the afternoon of July 8th, 2022, 1 week late and only fewer than 3 days before Plaintiff Depp's deadline for submitting his opposition to defendant's post-trial motions due on Monday, July 11th by no later than 10 a.m. So, this is fun stuff because when it comes to deadlines, courts can be as strict as they want to be, right? Like the easiest way to dismiss any claim is if you have a statute of limitations argument, meaning in order to bring a cause of action against a defendant, you have a certain amount of time to bring that cause of action. It depends on what we're talking about. Sometimes, if it's a DV case, you might have longer. If it's a contract case, it might be just 2 years, 3 years. It depends. Defamation in this particular case, I think was 1 year, if I remember correctly. So you have a certain amount of time. And as soon as you hit that deadline, courts are like, Sorry, easy dismiss, done. And there's a good reason for that. It's because courts don't want people to be languishing in litigation forever or under the threat of potential litigation for the rest of their lives. And on top of that, the longer you get from the recency of the events that gave rise to that particular claim, the more you've got memory issues, the more you've got perception issues, the more you've got witnesses that are disappearing because they move or they die or they get sick or all these kinds of reasons. So there's all these kinds of reasons why courts can be very strict on the issues of deadlines. And the statute of limitations is like one of the best examples of that, one of the strongest examples of that. But when it comes to a court like this setting a certain deadline saying, hey, you've got a certain amount of time to file any kind of a motion, a post-trial motion on this particular verdict. It could be statutory, in which case, too bad, so sad. It could also be that that's just the local rule. I wasn't paying attention for this particular deadline to know whether that was a local rule or whether it was statutory in Virginia, in which case there could be varying levels of flexibility on that particular deadline. But if you miss a deadline, again, like I said, when you have any kind of a supplement to a motion, supplement to a brief that you file like a week later, like I said, I've had bosses that would be livid about that practice. And they would be like, look, like the fact that this happened once sucks. I don't like it. I never want to see it again. Don't do it again. Don't ever do that again, because it just looks lazy. It looks sloppy. It looks like we don't know what we're doing. And I'm sure folks watching this are gonna watch and say, well, we all know that they don't know what they're doing. We watched 6 weeks, 2 months of trial, and we know that like this is exactly what we should expect from Elaine at this point, right? So this argument is a very good argument to start with. Number two. Oh, sorry, I didn't actually finish this apparently. True to form, defendant. Oh, true to form. That's some shade right there. True to form. Defendant neither notified plaintiff of her forthcoming settlement memorandum nor sought leave of court for filing it 1 full week at a time because Ms. Heard filed late and without leave of court. The court should grant plaintiff's motion to strike. That is another point, is that when it comes to certain deadlines, let's say, for example, in the discovery process, there are deadlines that you have to meet in order to respond to a particular request. Let's say you're representing the plaintiff in the case, and the defendant sends you some discovery requests. Let's say they're requesting all these documents from you. You've got by default 30 days to respond with all those documents. You've got to respond substantively to their questions, whether you have objections to their questions, whether you say, nope, that's improper, you're not entitled to that information, or whether you say, okay, we'll give you that information. We'll give you those documents. You have a certain amount of time to respond. But if you engage with them in conversation beforehand and you realize, oh crap, I'm not going to make this deadline because there are so many documents that they need, and there's just absolutely no way that I'm going to be able to get this on time, and I really want to do my due diligence and get them what they're entitled to, no more, no less. You can do what's called meet and confer. You can meet with them by phone, by email, however, and say, hey, I need a continuance. I need an extension. Give me a week. Give me 2 weeks. I don't know, like whatever it is. That is a very regular thing in litigation. Maybe in some areas of the country, maybe in some areas of law, it's more or less of a common practice. But in my experience, I have seen that a lot in litigation, especially in the discovery process, because you're just trying to get information from one side to the other, and sort of figure out where this is going to resolve. So what he's saying here, basically, what Ben Chu is saying here is that true to form, defendant neither notified plaintiff of her forthcoming supplemental memorandum nor sought leave of court for filing it 1 full week at a time. Basically saying, look, if you knew that you were going to need extra time on this, you should have let us know on the opposing side. You should have let the court know, and you should have asked if it was okay for you to have a little bit of an extension to get your motion in, rather than trying to like sneak this, not even in the 11th hour, sneak this in the 13th, 14th hour, right? Because he's saying it's an entire week late. The problem with trying to get an extension sometimes for some people is when they try to do that late, when the deadline has already passed, and then they're like, oh wait, by the way, can I have an extension? That's not proper. You have to do it before the deadline actually passes. So by saying, hey, we filed our motion, and oh, by the way, we've got more information here that we just discovered, even though it's super obvious, it's not a good enough argument. And it's a really improper use of the process. So, all right. Argument number 2, they say Ms. Heard had access to the purported new facts months ago, right? That's why I'm using air quotations. In her supplemental memorandum, Ms. Heard does not, because she cannot, make any proffer as to why she could not have discovered the new, quote unquote, new facts until now. This is because the clerk's office provided the pre-panel jury list to the parties back on April 6, 2022, more than 2 months ago, and 5 days before the jury was impaneled. Let's read that again. This was because the clerk's office provided the pre-panel jury list to the parties back on April 6th, 2022, more than 2 months ago, and 5 days before the jury was impaneled. They had the information. They should have known that something was wrong. In a rare moment of candor, again, more shade. In a rare moment of candor, Ms. Heard admits that she was aware of the purported discrepancy in Juror 15th's birth year from the very start of trial because, quote unquote, Juror 15 was clearly born later than 1945, cites to motion at 40. Ms. Heard therefore concedes she had more than enough time before the trial started and during the 6-week trial when at least 2 alternates were available to investigate and discover the alleged new facts. Clearly, Ms. Heard waived any right to allege new facts. She chose not to investigate for so long, much less to demand the extraordinary remedy of a mistrial. So, once again, you can't just hold an argument in your back pocket and then use it later just in case you lose. I know a lot of people have been saying that's their strategy. That's a losing strategy because I don't know of any court anywhere in the country that is going to go for that. Like I said, objections must be made. Objections must be made timely. If they didn't object ever to this juror, they didn't say anything was amiss about this juror, they waive it. And we'll get into the specific law on that shows exactly what the requirement was for them to either make that objection or to argue later on that they are entitled to a mistrial. Number 3, Ms. Heard cites no unfair prejudice. This is it right here. Even if Ms. Heard had filed her supplemental memorandum in a timely manner, which she did not, more spice from Spicy Benju. And even had she not waived her right to raise this alleged issue by sitting on the information for more than 2 months, which she did, the court should still grant plaintiff's motion to strike defendant's supplemental memorandum because Ms. Heard failed to cite any unfair prejudice. Even assuming arguendo, Ms. Heard's latest thesis, i.e. that a son served instead of his father, there would be no prejudice as Juror 15 was qualified to serve as a juror in Fairfax County and was vetted by the court and the parties' counsel just as all of the other jurors were. Boom. Boom. It's right there. That's it. Conclusion. Based on the foregoing, the court should grant plaintiff's motion to strike defendant's supplemental memorandum. And let's take a look at this footnote here. Defendant seems to have abandoned her prior baseless assertions made both by Ms. Heard and her counsel on national television. Ooh boy, we're revving it up one last time. One last little. That the jurors violated their oaths by watching social media during the trial, which in turn influenced their verdicts. Disgraceful that Ms. Heard made such scandalous allegations, and disappointing that no apology and recantation followed. What can we expect? Right? Okay. So that's the spice. Let's get to the law here on jury irregularities. Give me a second here. I'm gonna share some new screens. Talk amongst yourselves. Okay. Okay. Here is Virginia Code Section 8.01-352. And shout out to Rob, Lumber Law. He made this super easy for me. I'm not gonna lie. I saw his tweet and I was like, "Yep, that's perfect." I'm gonna go follow on this little breadcrumb train. He cited to this particular statute and also the case law that we're going to take a look at. We're going to evaluate it. Excuse me. Okay, so this is talking about the jury being sworn, whether objections can be made without leave of court. We can skip right down to B. It says, unless objection to such irregularity meaning irregularity about something of the jury, right? That there was some sort of a juror, something happened with their selection, something wrong, right? Unless objection to such irregularity or disability is made pursuant to subsection A herein, and unless it appears that the irregularity was, okay, hang on. Let's go back to A. So A has to do with making, okay, let's just read it. I was going to try to summarize it, but let's just read it. Prior to the jury being sworn, the following objections may be made without leave of court. 1, an objection specifically pointing out the irregularity in any list or lists of jurors made by the clerk from names drawn from the jury box or in the drawing, summonings, returning, or impaneling of jurors, or in copying or signing or failing to sign the list. And 2, an objection to any juror on account of any legal disability. After the jury is sworn, such objection shall be made only with leave of court. So basically saying, as soon as you have impaneled the jury, you've got to request leave of court in order to object. Your time to object is before they've been impaneled. You've got to, if you see something, say something. If you see something, say something, but do it quick. Do it before your time is up. Just like any other objection at trial. And then B, unless objection to such irregularity or disability is made pursuant to subsection A herein, and unless it appears that the irregularity was intentional or that the irregularity or disability to be such as to probably cause injustice in a criminal case to the Commonwealth or to the accused, and in a civil case to the party making the objection, then such irregularity or disability shall not be cause for summoning a new panel or juror or for setting aside a verdict or granting a new trial. In other words, so they have to show, Amber Heard's team has an obligation, a statutory obligation under the Virginia Code to show that either there was something intentional going on with this irregularity, meaning it was intended by, I don't know, the clerk, maybe the juror, Johnny Depp's team, someone, right? It has to be that the irregularity was intentional, or that it was such as to probably cause injustice to the party making the objection. Where's the injustice? That motion that we went through about Juror 15 says nothing about how the fact that there's supposedly this discrepancy about the juror, about who should have been Juror 15 as opposed to who ended up Juror 15, that there was some kind of an injustice that resulted from that. How you have to draw that link. There's a certain stepping stone that you've got to step on in order to get to the next side. You can't skip it. So, but that's my reading of it. How about what some case law says about it? Let's look at the Virginia Supreme Court. Doesn't get stronger than that when it comes to analyzing the Virginia Code, right? I mean, I guess you can have a case going to the United States Supreme Court, but realistically, when we're talking about case law on the statutes for Hey, Law and Lumber. Yeah, I did. I found the cases. What's up? How's it going? I see you. So yeah, we've got Euler v. Ramsey. And I'm skipping half of it. It's a very short opinion. It's like a page, but I'm skipping half of it because it's not really relevant to what we're talking about. It says, defendant also complains of the trial court's refusal to set aside the verdict and grant a new trial. The ground upon which a new trial was sought in the lower court, because this is the Virginia Supreme Court, the ground upon which a new trial was sought was that one of the jurors and the plaintiff's counsel had stood mute when the trial court asked the prospective jurors on voir dire, do any of you have any close business relations with either of the parties or any of the attorneys in the case? It was alleged in the motion for a new trial the defense counsel had learned after the verdict was returned that the plaintiff's counsel at that time of trial was representing one of the jurors in a property damage claim pending in a court not of record. I'm not going to lie to you. That sounds pretty shady. The fact that there was a juror who was also being represented by the opposing counsel at that time on a different kind of a matter, but still, like that's a pretty strong connection, right? To say like, yeah, this is my lawyer. I understand how they communicate, and I also have an interest in them succeeding because I want them to do well, because I also want them to do well in my case. You know what I mean? Like that's the kind of case that's like, oh shoot. When you read the facts of that is allegedly what happened. Interesting. But let's read on in this opinion. What happened and what did the court decide here? What did the Virginia Supreme Court decide? Since the point was raised on a motion to set aside the verdict, the question is controlled by Code Section 808-202, which reads in part as follows. And by the way, the reason this is a different code section than what we just read on the last tab, and that's because it's been amended. But the basic code section it's essentially the same thing. It's been somewhat amended, so sort of a little bit changed, but the gist of it is there. Also, hey, boss attorney Bree, how's it going? I like to see you in the chat too. hey, good to see you again. Let's see here. Okay, so then they go to let's get back to right here where they quote Code Section 202, which says no irregularity in any writ of venire facias or in the drawing, summoning, returning, or impaneling of jurors shall be sufficient to set aside a verdict unless the party making the objection was injured by the irregularity, or unless an objection specifically pointing out such irregularities was made before the swearing of the jury. Since no objection was made before the jury was sworn, it was incumbent upon the defendant to show that he was injured by the alleged irregularity and impaneling the jury, or in impaneling the jury, sorry. That has not been shown, and the trial court's action in refusing to grant a new trial will not be disturbed. And then it cites to Davis v. Webb, another Virginia Supreme Court case. Yeah, pretty solid there, right? Pretty solid. The other points raised by the defendant were not saved by proper objection in the trial court. We will not notice them now. So that's basically it. That's it right there. So the Virginia Supreme Court now of course this is from 1971, and since then the actual statute has been amended, but it basically says the same thing. So it's pretty clear in my book. All right, so let's go to another appellate case just to sort of hammer this in, right? Because I don't know, maybe someone is not really convinced that, like, you know, oh, it's a really you know, it's a bad situation where you have the opposing counsel and a juror, both of them saying, I'm not going to say that I have a connection to this other person that might actually impact the outcome of trial. But the opposing side doesn't make the argument that it actually impacted the outcome, right? It didn't, that it somehow prejudiced them, that it somehow harmed them as a result. Let's just say that you're like, no, that's not egregious enough. That's not as egregious as, you know, the court making an error in who this person is and identifying this person. Well, how about this case, Mighty v. Commonwealth, that says, we affirm Mighty's conviction because there's no evidence that the irregularity would probably cause Mighty injustice. This is a case where, sorry, I probably should have Sorry, I should have queued this up better. I forgot to pull this up. Okay, so you have a case here where you've got not one but two jurors who are felons, and they're not supposed to be on the jury list at all. And when they were asked on the jury questionnaire, have you ever been convicted of a felony? They responded no, which was an actual affirmative lie. Both of them did, apparently. But the court, the underlying court, found that because an objection had not been raised prior to the jury being sworn, prejudice or injustice must be shown. Prejudice or injustice must be shown. Therefore, it would not set aside the conviction because they didn't. They did not make that argument. The opposing side did not make the argument that any prejudice or injustice had resulted, that had come about as a result of the fact that that juror was a felon and had lied about being a felon. So, and by the way, this is the clerk's office that was responsible for this stuff. On July 6, 1992, the clerk's office discovered that a second juror from the trial was a previously convicted felon. That juror also responded no to the question on the jury questionnaire concerning whether she had ever been convicted of a felony. Mighty's counsel filed a written motion to vacate the judgment, again raising the issue that Mighty had been denied his right to a trial by 12 qualified jurors. The trial court held that under a felon is within one of the three categories of persons disqualified from serving on a jury because of certain disabilities. This is someone who is just like categorically disqualified from serving on a jury. So like we don't have that in the Depp v. Heard juror 15 situation, right? Because all we have is potentially mistaken identity. They haven't asserted anything about that the man who ended up serving on the jury, it shouldn't be, is unqualified to serve on any jury, period, because of something like this, where they're a felon and they're felons are not supposed to serve on a jury. So then the appellate court says, we affirm Mighty's conviction because there's no evidence that the irregularity would probably cause Mighty injustice. And then they say the trial court's findings of fact on this issue are entitled to great weight, and we find them to be supported by the record. Here's the thing. We're talking about facts on a record. We're talking about the trial court's discretion. What we've said before about a potential appeal in this particular case is when we're talking about evidence coming in or going out, those are all decisions that are up to the discretion of the judge. And so in order for an appellant, so someone who is appealing the case, to successfully argue that evidence was improperly left out, the appellate court has to find that it was an abuse of the judge's discretion to leave that evidence out. It's a very high burden. So anytime you see appellate case law saying that the court had discretion in a particular decision, high burden to try to overturn that. And right here it says, the exercise of the trial court's discretion will not be interfered with unless it appears that some injustice has been done. Code section 8.01-352 provides that the mechanism for dealing with objections to irregularities in jury lists and to alleged legal disabilities of jurors. Subsection A states that prior to the jury being sworn, a party may object without leave of court to any juror on the basis of any legal disability. It further provides that after the jury is sworn, as in this case, any such objection requires leave of court. Unless objection to such irregularity or disability is made pursuant to subsection A herein, remember the subsection that we went over earlier, and unless it appears that the irregularity was intentional or that the irregularity or disability be such as to probably cause injustice in a criminal case to the Commonwealth or to the accused, then such irregularity or disability shall not be cause for summoning a new panel or juror, for setting aside the verdict, or for granting a new trial. Boom. All of that right there. For some reason, it's not letting me highlight it. Let's continue reading. Code section 8.01-352B, by explicit it cites that, sorry. By explicit statutory command, even if the trial court grants leave to object after the jury is sworn, a verdict in a criminal case is not to be set aside and a new trial ordered unless the legal disability was of such a nature as to probably cause the defendant injustice. Now, I've seen a little bit of commentary on Twitter for some reason saying, well, this case isn't applicable to Johnny Depp versus Amber Heard because that's talking about criminal law and this is a civil case. It doesn't matter because the statute in question that's being analyzed by the court, it explicitly applies to both. It applies to criminal cases. It applies to civil cases. It applies to criminal cases in the way in which it's applied in this particular case law, in the same way that it would apply in the pertinent issue in Depp v. Heard, right? So, like, don't let that distract you. If someone is saying that, like, oh, like stuff like this is talking about criminal law versus civil law, that's a nothing burger. Here, there has been no showing of probable injustice. Mighty asked no questions of the prospective jurors on voir dire, and the jury was sworn without objection. After Mighty was convicted, the felony status of the two jurors was discovered, and he was given two separate opportunities to demonstrate the required prejudice. You have to demonstrate the prejudice. No evidence was presented to the court to suggest that the two jurors' legal disability as felons would probably cause injustice to Mighty. Therefore, we find no basis to set aside the verdict, vacate the judgment, or order a new trial. You don't check the box, you're going to lose. It's an element of the argument. 3, Mighty's assertion that Section 8.01-352 does not apply because felons are disqualified and do not merely possess a legal disability is incorrect. The Supreme Court of Virginia has expressly recognized that a prospective juror who has a felony conviction is a person with a legal disability. Because the record does not reveal that a matter of law, the irregularity probably caused the defendant injustice, we affirm Mighty's conviction. So even in a case where you have not one, but two jurors who not only were legally disabled because they were felons, but number 2, they actually lied about it on the questionnaire. That's a pretty bad case. That's pretty bad than like a simple, like, oh, oops, is it dad or son kind of situation? They both live at the same address. Like that kind of a simple mistake. Like this is like seemingly intentional that they're like, yeah. I know that you want me to not be on this jury. I'm going to get my butt on this jury. Because I mean, like how else could you look at a case like that where somebody literally lied about not being a felon when they were actually a felon, right? So this case law seems to point to a situation that is more egregious than the juror 15 situation, assuming that you even like agree with Amber Heard's team's like background argument that like this is even happening in the first place. So, yeah, that's the case law on that issue of juror number 15. What do you guys think? Let us know in the comments down below. And if you guys are enjoying this, I would love it if you guys would like the video. It's been a minute since I said something like that. So it does help us, of course, it does help us with the YouTube algorithm gods. And yeah, I really appreciate all of you guys. By the way, shout out to all the mods. It's been a while since we got to hang out as well. And I'm really happy to see you guys. And I really appreciate all of the work that you guys have been doing over the months, especially. And it's been a while since I've had an opportunity to say that. So thanks, guys. Thanks. Okay. Let's now talk about the New York Marine and General Insurance Company versus Amber Heard. Let's talk about it. Let's go through it. It's a short enough complaint that we can definitely go through this word for word. I think Holmes will be okay with that. Right, Holmesy? Hi, kitty. Okay, he's chilling as usual. Okay, anyway, let's go. Let's do this, shall we? It's simple enough. Alrighty. Share screen. Okay. And please excuse my slight sniffling too, by the way, because I did end up with a cold after all that energy and stress and organizing and everything after trial, after wedding, all that stuff. Like the day after the wedding, I wake up and I'm like, oh no, I might be getting sick. Don't worry, it's not the coof. It's a normal cold, tested negative for all that other stuff. Fun fact, seasonal cold still exists. I know for a fact. Anyway, just getting over it. Okay, so here's the complaint for declaratory relief in demand for jury trial. Declaratory relief meaning that what they are looking for here is a declaration from the court telling them that something should happen or should not happen. Somebody has an obligation, they do not have an obligation. That's more what we're looking at here. Okay, so we're going to skip over the jurisdiction and venue part because this is all in federal court, and so they have to go through all this blah, blah, blah as to why this is properly in federal court as opposed to state court. We've got diversity jurisdiction, meaning that the parties are coming from different states. Anyway, let's get into the juice, shall we? Factual allegations. The insurance policy. So, I guess as background context, this is being brought by the insurance company that apparently insured Amber Heard for personal liability, personal injury, and now they're suing for some reason. Why is the reason? You probably, I mean, realistically, you may have seen another law tuber or maybe Laura or Jax or somebody else going over this, but it's fun anyway. Let's go through it anyway. Okay. The insurance policy. New York Marine issued insurance policy number blah, blah, blah to named insureds under the Black Sky Inc. and Amber Heard for the policy period July 18th, 2018 to July 18th, 2019 with a per occurrence limit of liability of $1 million. Here and after the policy. A true and correct copy of the policy with premium and address information redacted is attached here to as Exhibit A. The policy includes a comprehensive personal liability coverage part, which provides coverage for damages because of bodily injury, property damage, or personal injury caused by an occurrence to which the coverage applies. The policy defines personal injury to mean injury other than bodily injury arising out of one or more enumerated offenses included in the policy, which includes oral or written publication of material that slanders or libels a person or organization, including other forms of defamation, and oral or written publication of material, including other forms of defamation that violates a person's right of privacy. Basically saying, we were insured just in case she was going to get a defamation claim, which is fine. People will do that. I mean, that's why you get insurance policies on anything, right? It's just in case something happens to you concerning whatever it is that they cover, whether that's medical insurance, whether that's automobile insurance, home insurance, all kinds of things. That's why you get it, right? It's just in case. The underlying lawsuit. Now we know what this underlying lawsuit is, right? We are very familiar with this underlying lawsuit, but they go through and they say on March 1st, 2019, John C. Depp II, Depp, filed a lawsuit against Heard in the Circuit Court of Fairfax County, Virginia, also known as the underlying action. In the underlying action, Depp sought and is seeking damages for defamation based on an op-ed allegedly written by Heard and published in both the online edition of the Washington Post on December 18th, 2018, and in a print edition of the Washington Post on December 19th, 2018. A true and correct copy of the complaint filed by Depp in the underlying action is attached here to as Exhibit B. On or about September 4th, 2019, Heard tendered the underlying action to New York Marine. Interesting to me that she was sued on March 1st, and then 6 months later, she tendered the action to New York Marine. That's interesting to me. I mean, I guess it's neither here nor there, but it's interesting to me that she didn't do that right away. Hey, Kurt, how's it going? I see you in the chat too. Good to see you. On October 1st, 2019, New York Marine accepted Heard's defense of the underlying action subject to reservation of rights. Specifically, New York Marine advised Heard that New York Marine would provide a legal defense, but that to the extent California law does not permit an insurer to indemnify the insured, no indemnity can be provided. Ooh, a bit of foreshadowing. Narrator. Narrator says there was going to be a California law issue that comes into play. Let's read on. I'm cracking myself up here, guys. I'm sorry if you don't find any of my jokes funny. Sorry, I'm not sorry. Anyway, let's continue. At the time Heard tendered the underlying action, the law firm Cameron McAvoy PLLC was defending Heard in the underlying action. When New York Marine accepted Heard's defense, New York Marine agreed to continue the defense of Heard through the law firm Cameron McAvoy PLLC. So this is common, right? When it comes to having an insurance company represent your litigation, it's common for them to say, yeah, that's fine. We'll pay for the litigation, but we're going to pick the lawyer that's going to be working on it, or we're going to pick the firm that's going to be working on it. We want our people to be working on it. I've litigated cases opposite from lawyers that were specifically hired by a particular automobile insurance company, for example. And that's just what they do. So oftentimes you'll have that. So that's not terribly uncommon. New York Marine is informed and believes, and on such information and belief alleges that Heard or her agents instructed other firms defending Heard in the underlying action to not include Cameron McAvoy and Heard's ongoing defense. As a result, on or around November 2nd, 2020, Cameron McAvoy withdrew from the defense of Heard in the underlying action. Interesting. Very interesting. I wonder why. Like, I wonder why they said, hey, nobody talk to this guy. We don't like him. He smells. I don't know. I'd like to see more detail on what transpired around then. But 2012 Jameson, you're right. Insurance company or insurance rule number 1, always try not to pay a claim. 100%. They are there to run their own business, right? And it costs them money to pay out a claim. It's a lot more profitable for an insurance company to never have to pay out on a claim, because that means that they are getting policy premiums from all of the people that they're insuring, and nothing bad ever happens. So they just keep collecting that and don't have to pay anything out. That's also why when you actually do end up needing insurance for something because something has happened, let's say you get into a car accident, after that, you'll notice that your policy premiums will usually go up, at least for a certain period of time. Continuing on. The underlying action proceeded to trial beginning on April 11th, 2022, as of course we all know. On May 27th, 2022, the court in the underlying action issued jury instructions to the jury. A true and correct copy of the jury instructions are attached here to as Exhibit C. In the jury instructions, the court in the underlying action instructed the jury that with respect to liability issues for Depp's claims against Heard, the jury verdict must be based on the facts as you find them and on the law contained in all of these instructions. Of course. The jury instructions also instructed the jury that with respect to liability issues for Depp's claims against Heard, the issues for the jury to decide were, first, whether Ms. Heard made or published any of the following statements. And then, of course, we know the 3 statements. I'm not going to go into detail on these. We can skip through that. But, I spoke up against sexual violence and face of culture's wrath, blah, blah, blah. Okay. As a finding instruction, the court in the underlying action instructed the jury that it shall only return your verdict for Mr. Depp on his claim for defamation if Depp has proved by the greater weight of evidence that, 1, Ms. Heard made or published the following statement. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And the statement was about Depp, and the statement is false. And the statement has a defamatory implication about Mr. Depp, and the defamatory implication was designed and intended by Ms. Heard. Flag that one because it's important. And due to the circumstances surrounding the publication of this statement, it conveyed a defamatory implication to someone who saw it other than Mr. Depp. And if Mr. Depp further proved by clear and convincing evidence that Ms. Heard made the statement with actual malice. Super important. Super duper important, because we're talking about not just a normal defamation case, right? We're talking about a defamation case that has been brought by a public figure. And so there is a requirement for actual malice. And once again, for the louder for the folks in the back, what is actual malice? Actual malice, of course, means that the defendant not only lied, but they lied either intending to lie knowingly, knowing that what they were saying was false, or with reckless disregard as to the truth or falsity of the statement. So it's got to be at least reckless, but definitely more than negligent. So, but yeah, and civil lies. You missed the designed and intended part of the verdict. It's there, designed and intended. So we actually have two parts of these jury instructions that the insurance company is probably going to point to for why they should not have to pay for Ms. Heard's legal fees here. Let's continue on. The court in the underlying action issued a nearly identical finding instruction for each of the other two statements identified in paragraph 20 above, which only charged the content of the first element to replace the statement of the issue. On June 1st, 2022, the jury in the underlying action returned a verdict in favor of Depp for counts of defamation based on all three statements. We remember that day, right? Remember that day? My niece was born on that day. She was born on verdict day. I'm so happy about that. Now every single one of her birthdays, we can celebrate with her and say, hey, happy birthday. Also, today's verdict day. Don't you know? Today was the day that Johnny Depp was freed from Amber Heard. Anyway, that's just a funny little tidbit. So this verdict was incorporated into a judgment order, which was entered by the court in the underlying action on June 24th, 2022. A true and correct copy of the judgment order is attached here too as Exhibit D, as detailed in the special verdict form. With regard to each of the three statements at issue, the jury found that Depp had proven all the elements of defamation and answered in the affirmative to all of the following questions. The statement was made or published by Ms. Heard. The statement was about Mr. Depp. The statement was false. The statement had a defamatory implication about Mr. Depp. The defamatory implication was designed and intended by Ms. Heard. Emphasis added by me in reading this. The defamatory implication was designed and intended by Ms. Heard. Due to circumstances surrounding the publication of the statement, it conveyed a defamatory implication to someone who saw it other than Mr. Depp. After answering all of those questions, yes, the jury also answered yes to the question, do you find that Mr. Depp has proven by clear and convincing evidence that Ms. Heard acted with actual malice? After answering, the jury awarded Depp $10 million in compensatory damages, woohoo, and $5 million in punitive damages from Heard, yes. However, the punitive damages were reduced to a statutory cap of $350,000 pursuant to Virginia Code, Section 8.01-38.1. Okay, that's the facts right there. What does it all mean? Let's get into the first cause of action. There's four of them. They're very similar. So the first one, they're asking for declaratory relief as to plaintiff's duty to indemnify Heard for the judgment order under the policy. So specifically for the judgment order. Plaintiff incorporates by reference, blah, blah, blah. California Insurance Code Section 533 provides that an insurer is not liable for a loss caused by the willful act of the insured, but he is not exonerated by the negligence of the insured or of the insured's agents or others. This provision is an implied exclusionary clause, which by statute is read into all insurance policies under California law. Let's take a look. Let's just double check, because it's always a good idea when you come across a citation in a filing. It's always a good idea to double check that what they're citing is actually the law. So here's California Insurance Code Section 533. Yep, looks like it. An insurer is not liable for a loss caused by the willful act of the insured, but he is not exonerated by the negligence of the insured or of the insured's agents of others. Basically saying, if there is something that the defendant is found to have intentionally done, the insurer is not liable for it. The insurer does not have to cover it. The insurer doesn't have to pay for it. Let's take a look at a little bit of case law here. Downey Venture, I don't even need to dig too deep into these, right? We can just show this right here. Downey Venture, the LMI Insurance Company, says in Downey Venture, the California Court of Appeal held that a willful act under Section 533 will include either an act deliberately done for the express purpose of causing damage or intentionally performed with knowledge that damage is highly probable or substantially certain to result. Yeah, that's we're in Amber Heard land. We're in actual Malice land. We're in designed and intended land. Let's take a look at. But that's one California appellate court from 1998, cited 242 times. So it's pretty strong binding authority here in California. Let's see. How about this one? Was this the one that I was looking at? American States Insurance Company v. Borber by Borber, holding that because California Insurance Code Section 533 is equivalent to exclusionary clause, it must be construed strictly against insurer, and on that basis, holding that where policy listed two individuals in a partnership made up of those individuals as the insured, one of the individuals is entitled to coverage for liability incurred by partnership. Okay, so one of them was entitled to it. So basically saying where you've got a bunch of people and one of them wasn't shown to have acted intentionally, you can say that they're still that the insurer still has to pay for them. That's not the case here. How about this one? Noting that the parties did not dispute that Section 533 precluded coverage where injuries resulted from battery by insured during a bar fight. So as an example, when you're trying to get litigation paid for, you're the defendant, you're insured for personal liability, but the underlying action is that you got into a bar fight and you intentionally started a bar fight. Yeah. That's you're not gonna get covered for that. Anyway, so that's California Insurance Code Section 533. Let's get back to the actual filing here. Give me a second so I pull this back up again. Okay. The jury's factual findings established that Heard's liability is caused by the willful acts of Heard. As a result, as a matter of California public policy, and pursuant to California Insurance Code Section 533, the policy does not provide coverage for Heard's liability as reflected in the judgment order entered on June 24th, 2022. An actual controversy has arisen and now exists between plaintiff on the one hand and Heard on the other hand with regard to the duties and obligations owed between plaintiff and Heard under the policy with respect to the judgment order. Plaintiff contends that it has no duty to indemnify Heard for the judgment order entered on June 24th, 2022. Plaintiff is informed and believes, and on such information and belief alleges, that Heard disputes plaintiff's contention and asserts that the policy provides indemnity coverage for Heard for the judgment order entered on June 24th, 2022. In other words, yeah, the whole $10 million plus the $350,000 doesn't need to come from doesn't need to come from them, from the insurer. And 2012 Jameson also says California law governs because of venue clause, it seems. It probably governs because of the policy, actually. I don't have a copy of the policy at this point, but my guess is that they probably say that the law that is governing is the law in which you reside, or that the state in which you reside, maybe. Probably. Yeah. So that's usually how that happens. As I'm sure you know, because 2012 Jameson is also a lawyer. Let's see, where was I? I think I said an actual controversy now exists. Of course, plaintiff is informed and believes, and on such information and belief alleges that Heard disputes plaintiff's contention and asserts that the policy provides indemnity coverage for Heard for the judgment order entered on June 24th, 2022. Yeah. Due to the actual and present controversy described above, pursuant to 28 Code 28 U.S. Code, Section 2201, plaintiff requests a judicial declaration of the rights, duties, and obligations under the policy, determining that if said judgment order entered on June 24th, 2022 becomes final on appeal or otherwise, plaintiff has no obligation to indemnify heard for the judgment order. So in other words, what they're saying here is that they're asking for the court to say, all right, I see that there's a potential for some exchange of money based on this policy, but yeah, insurance company, you're not required to give any money. So, one second here. Okay. So yeah, this is what they're asking for. And you can do that. You can ask for declaratory judgment in a situation such as this. So, and to be clear, what they're asking for is they're saying that first, they recognize that first the judgment order entered on June 24th, 2022 has to become final on appeal or otherwise. So in other words, they're not saying like, hey, right now, real quick, before maybe she might end up winning, declare that we don't have to pay for her, even though, you know, right now the verdict says that she was acting intentionally and whatnot. They're recognizing that, yeah, of course, this has to make its way through whatever courts. If she decides to appeal, we've got to wait until the appeal. But basically, they're getting in there and they're saying, all right, let's get our ducks lined up in a row, right? If the circumstances don't change, we want declaratory judgment from the court to say we don't have to pay for her damages, and then as you'll see moving forward, for her attorney's fees at all. Second cause of action, declaratory relief as to plaintiff's duty to indemnify heard for any judgment in the underlying action. This is basically all the same thing. This is repeating pretty much the same thing about Section 533 and then the policy. And then it says, due to the actual and present controversy described above, plaintiff requests a judicial declaration of the rights, duties, and obligations under the policy, determining that plaintiff has no obligation to indemnify heard for any liability regarding the underlying action. Basically saying not just the judgment that was rendered on the 24th, but for anything having to do with this case. We don't want to have to. We don't want to be obligated to indemnify her for any liability connected to this, even if there's some kind of new liability that comes up as a result. We don't want to have to be responsible to pay for it. Third cause of action, once again, most of this is basically the same thing, talking about code section 533 about the California Insurance Code, and then saying, okay, and then they say, due to the actual and present controversy described above, pursuant to 28 U.S. Code Section 2201, plaintiff requests a judicial declaration of the rights, duties, and obligations under the policy, determining that with respect to defense of heard, plaintiff has no obligation on an ongoing basis for the underlying action. Basically saying, judge, don't make us pay for her defense. Don't make us pay for her attorney's fees moving forward, because we shouldn't have to. She acted intentionally. The jury found that. And then the fourth cause of action. The fourth cause of action is declaratory relief as to plaintiff's duty to defend heard in the underlying action under the policy, having to do with the conditions of the policy itself. So this is a little bit different. This is the one that's a little bit different. Everything else is citing to Section 533 of the Insurance Code. This is looking at the actual policy itself, the terms of the policy itself, which we don't have in front of us other than what they are quoting here. So because I don't have access to this Exhibit A that they have apparently attached to this complaint, I kind of have to take this at face value. So assuming that this is correct, this is what we're gonna do. Okay, the comprehensive personal liability coverage part of the policy provides under conditions, duties after loss, that heard must help New York Marine by seeing that enumerated duties are performed, including helping New York Marine with the conduct of suits and attending hearings and trials. New York Marine is informed and believes And on such information and belief alleges that after New York Marine accepted Heard's defense, Heard, both individually and through her agents, refused to help New York Marine with the conduct of the suit and instructed other defense firms representing Heard not to include defense counsel provided by New York Marine in the ongoing defense of Heard in the underlying action. Basically, what they're saying is, you've got to include us in the process if you want us to pay for it. And she didn't include them in the process. They were giving explicit instructions for whatever reason to ignore the McAvoy firm, play stupid games, win stupid prizes, I guess. Yeah, this is they're saying, look, they had an obligation per the terms of the policy to include us, and they didn't. And so therefore, what are they going to ask for? Let's read on. An actual controversy has arisen and now exists between plaintiff on the one hand and Heard on the other with regard to the duties and obligations owed between plaintiff and Heard under the policy with respect to whether New York Marine is obligated to defend Heard in the underlying action. Plaintiff contends that it has no duty to defend Heard based on her failure to comply with the conditions of the policy. Plaintiff is informed and believes, and on such information and belief alleges that Heard disputes plaintiff's contentions and asserts that the policy obligates New York Marine to continue to defend Heard on an ongoing basis in the underlying action. Due to the actual and present controversy described above, pursuant to 28 U.S. Code Section 2201, plaintiff requests a judicial declaration of the rights, duties, and obligations under the policy, determining that plaintiff has no obligation to defend Heard on an ongoing basis in the underlying action. No obligation to defend. So, yeah, that's fun times, right? So there you have it. Prayer for relief. This is what they're asking for. They're asking for declaring a judgment declaring a judgment declaring the plaintiff has no duty to indemnify Heard for the judgment order entered on June 24th, 2022 in the Circuit Court of Fairfax County, Virginia. That plaintiff has no duty to indemnify Heard for any liability in the Circuit Court of Fairfax County, Virginia. Same. That plaintiff has no duty to defend Heard on an ongoing basis in the underlying action or in connection with any appeal of the judgment in the underlying action. Basically saying, look, she's going to try to fight this until forever, and she wants us to hold the bag, right? To carry to be the bag holder in all of this. This is just going to cost us a ton of money, and it's improper. And then they're asking to award New York Marine its costs and to grant such further relief as this court deems just and proper, which is that's pretty basic default language at the end. So yeah, that is what this whole case is about. Fairly simple. Basically saying, look, there are two main issues, two problems here for Amber Heard here in terms of getting her legal fees paid for and the judgment costs paid for, right? The judgment that she's supposed to be paying to Johnny Depp to have that insurance company cough up all that money. She's got two problems here. Number one, the jury found that she was acting intentionally. Now, of course, if this goes up to an appeal and the court says, okay, well, we're gonna declare a mistrial or dismiss the complaint or whatever, then there is technically no jury verdict saying that she acted intentionally, right? So then she can have this whole argument saying, well, no, that means that you don't have anything showing that I acted intentionally for this defamation case because that jury verdict was found to be improper. So you can't hang your hat on that, essentially. On the other hand, if and when the verdict stands, you've got a jury saying, with two questions they've answered twice, saying that she acted intentionally and then with actual malice. So there's that, and then there's the issue that for whatever reason Amber Heard's team did not include the McAvoy law firm in this whole process, the firm that was preferred by New York Marine and General Insurance Company. And the reason for that could be because there was just too many cooks in the kitchen, maybe because that firm was instructed to not be quite as bulldogish as they wanted to be. There could be all kinds of reasons for why they didn't want to work with that other guy. Maybe he just didn't even go here, right? Mean Girls quote, anyway, or Mean Girls reference. But I'm very curious as to like what actually went down. Like I have questions about that, right? As Emily D. Baker would say, I have questions. But interesting. We'll see how that goes. It was just filed. I think that as far as this filing is concerned, there's nothing to worry about as far as a motion to dismiss is concerned. And I think that so long as, 100%, so long as the verdict stands, this is going to be fine. And I see, 2012 Jameson said Uncivil just posted a link to Exhibit A. Yes, I did see that. And let's see if that is something that can be looked at very quickly. Okay. Hang on a second here. If you guys want to just bear with me for a second. I might be able to look at this on the fly while not boring you guys to death while I look at a 66-page policy. Let's see. I was hoping that I could just like Control F the word venue, and that didn't help. General liability. Talk amongst yourselves while I read this. Calculation of premium, disclosure. You know what? Why don't I just share this while I'm looking at it? Maybe that'll make it a little bit less boring for you guys. Although you guys are enjoying Holmesy, it looks like. Yeah, he's cleaning himself. he's maintaining his formality because he's a tuxedo cat after all. He's got appearances to keep up, right? Am I right? Okay. He's taking a shower. That's cute. Okay, terrorism risk, that's not really relevant here. Common policy conditions, cancellation of changes, premiums, transfer of your rights, examination of your books and records, inspection and surveys. Ideally, I would have looked at this ahead of time, but since I just got it, I've got to do this, I guess, right now. Nuclear energy liability exclusion endorsement. That's interesting. California changes. Okay, that reference to California makes it seem like that this is okay. Seems like California law would apply if they have a specific section that's dedicated workers' compensation, residents, employees, California. Yeah, this could just be that this is a California policy based on the fact that she lives in California. I'm trying to browse through this. Retroactive date, description of business. Business description, Shell Corporation. What? Oh, okay. I see. Never mind. This is a Shell. Okay, never mind. I was thinking like for some reason the Shell gas company. I don't know why I did that. Anyway, ignore that. Okay. Commercial general liability. Okay. I guess usually it should be at the end, right? Usually when I see governing law, maybe I can Control F governing law. No. Governing only has one, and that's not right. Oh, 249. Okay, well, let's see here. Okay. Compensation law. Okay. Continuing through here. Not relevant, not relevant, not relevant. Okay. Okay, Reporting Act, okay. Let's see here. New. Did I already go through everything? I think I did. I don't know. I can't. Let's see here. Maybe it's down here. It's usually, oftentimes I found that that kind of a provision is going to be like in fine print at the very bottom. I don't see. This is annoying. Okay, definitions. Maybe definitions here will have it. Okay, insured location. Personal injury. Occurrence, okay. Property damage, residence conditions, limited liability, severability of insurance duties after loss. Duties of an injured person. Okay, payment of claims suit against us. Other insurance policy period, subrogation, concealment of fraud, liberalization clause, waiver of change. Okay, it could be around here. Might be around a breach section, Jameson says. Huh. Okay. Waiver of. I would expect it to be back here somewhere. Cross liability exclusion. Cancerous diseases. Activities. Oh, geez. I can't. I might need to just look at this off air and then tell you guys. But my guess is that California exclusion. Okay. I don't know. There are so many references to California, and there aren't any references to any other state. But that, oh, it's on page 42. Okay, I see that in the chat. According to Colin, it's on page 42. Take a look. Sorry, guys. Employment-related practices exclusion. But this isn't, okay. No, I don't. Yeah, I don't see it. Okay. I might have to look at this later because I'm looking at page 42 here and I don't see it on here. So I'm probably going to have to look at this a little bit later. But Real Ron says, kind of turned into an ASMR channel. I like it. I appreciate that. And thank you for the blue hearts, guys. Thank you. It's like a legal Where's Waldo, says Keith Steve. Yeah, it kind of feels like Where's Waldo, right? Just trying to find a needle in a haystack. Okay, so, oh, you guys, very sweet for the blue hearts. It's like you guys are doing the wave during a baseball game. I love it. Okay, let's set that aside for now, and instead, what we'll do is we'll take a look at this right here. We'll turn to the next subject, which is the settlement here. We've got the next subject, which is the settlement of the Gregg Brooks. Gregg Brooks. Okay. Oh, well, okay. Hang on. One more. Let's do one more try here. Colin says page 42, paragraph 1, part C includes defamation. Page 42, paragraph 1, part C. You mean under A? AEC employment-related practices, policies are... I'm not sure. I'm not sure if I'm looking at the same page as you. Okay. I'm gonna go back then. We're gonna move on for now, and then I will I'll look at that later. And I'll see if I can find it. Anyway, so we have the Gregg Brooks versus Johnny Depp personal injury case, right? Where Brooks alleges that Johnny Depp punched him on set. There are witnesses that say otherwise. Witnesses that say otherwise, that say that in fact Brooks was yelling racist obscenities at a homeless woman who, if I remember correctly, I think there was also like she had a mental health issue on top of it, and that Johnny Depp came to the aid of that homeless woman, and that I think Brooks ended up being fired from that position, I think, if I remember correctly. So anyway, if that's the case, then I don't know if he really would have wanted to go to trial himself. There are benefits, there are costs to the fact that a case like this would be settled. Generally speaking, civil litigators like to see settlements because trial is high stakes. You either win or you lose. But with a settlement, you can control the conditions upon which you're able to walk away. Maybe not with a complete win, but also not with a complete loss either. So it's a way of mitigating risk. That's really what it's all about. It's a settlement is not, and I said this on Twitter, a settlement is not an admission of guilt. Yes, you can have terms in a settlement agreement where one side insists that the other side say that they admit to wrongdoing. I've never seen that in the settlement agreement, because the default is that the defense attorney is going to draft that and say, yeah, no, we're going to explicitly say that neither party is going to take this as an implication that any wrongdoing actually happened. That's the default that you see in any kind of a settlement agreement in the United States. And in order to negotiate otherwise, it probably would cost the plaintiff a very pretty penny to try to get there. And just in my experience, I think it can be hard enough to get the two parties to come and sit at the same table anyway, and to agree on a number that is going to be exchanged between the two parties. So the fact that some people want to say that there's some sort of an assumption of guilt in this is just not right. It's not right. It's not proper. It's just not the practice of settlements. So here's the document that was posted on Twitter by Real Laura B. Thanks again. Shout out to Laura B. This is the notice from the court saying that there is a hearing that is going to be a case review hearing. That's a non-appearance hearing. So basically meaning that the parties don't need to show up necessarily, but this is just a court deadline, basically saying they've gotten notice that there's a settlement here. Now there's a certain amount of time before the plaintiff files a dismissal of the case. And this is routine, by the way. It's routine that once you have a settlement, one of the material terms of the settlement agreement is going to be that the plaintiff agrees to dismiss the case with prejudice, basically meaning that they agree that to dismiss the case and that they can't come back and refile it. Without prejudice would mean that they have the ability at some later date to refile. That is generally how things work out, is that there's that dismissal there. So here it says, let me see if I can zoom in here. Ooh, extreme close up. Okay. If a dismissal is not filed, plaintiff is to file a declaration as to why the case should not be dismissed. The declaration is to be filed by February 9th, 2023. If the declaration is not filed, the case will be dismissed. And this non-appearance case review is set for February 16th, 2023. Why so long from now? Why does it take so long for something like that to happen? Well, typically what happens when you have a settlement like this is you have the two parties, they agree on the basic terms, basically saying, okay, I will give you this amount of money and you're going to agree to dismiss the complaint. Okay, fine. That's ultimately the number that we're going to agree on. Then the attorneys from both sides sit down together and they go through and draft the actual settlement agreement. So, and the reason why they'll do it this way is because there are all kinds of court deadlines, right? I mean, especially in a case like this, where this is July 12th today, the trial was supposed to start like a week from now or something. There are all kinds of trial court deadlines that the two parties have to meet that are pretrial motions in limine. They've got all kinds of binders that need to be sent to the court. They've got there's so much work. There's a flurry of work that has to happen in the weeks leading up to trial before you even get there on day one, as I'm sure many people are familiar by now that have been following the Depp v. Heard case for a very long time. But the reason why you want to get that notice of settlement to the court as soon as possible is because that basically effectively says, okay, we have all these deadlines that we don't have to meet. Everything gets frozen because we have a notice of settlement. The two sides agree that this is not moving ahead to trial. We are settling this case. It's going to go away. And so now let's get the specific terms of it figured out. Let's draft the agreement. Okay. There's a lot of going back and forth of editing between the two sides. I as the defense attorney, I email my version of the settlement agreement to them. They review it in detail and want to make sure, no, you tried to slide in this little term here that I don't agree with. And then they make their edits to it, and you can see they're redlining to it, and then they send it back, and then you go and review, did they try to sneak something in on me? So you go through and you review every single term, going through it. And it's a process going back and forth, not just sitting down and writing and then sending it over, but then when you're on the receiving end, going through every single detail, every single sentence, every single phrase in that settlement agreement before then saying, okay, this is fine. No, this needs to be changed. And oh, by the way, I need to, talk to my client about this. What do they think? So this is a whole very involved process. So that's one reason why that hearing would be set a little bit later. So yeah, so that's that. Now there are, like I said before, there are costs and benefits to settling a case of this nature. Generally speaking, 95% of cases don't make it to trial. Civil litigation cases, 95% of civil litigation cases do not make it to trial. And so that doesn't necessarily mean that 95% are settled, because there are also, I think probably within that statistic that gets generally cited places is there's also cases that get dismissed, there's cases that get withdrawn, and yada, yada, yada. But I think it's very safe to say that the majority of cases, the majority of civil litigation cases are probably settled. And there's all kinds of reasons for it. Generally speaking, I think that's a good thing. Because trial can be a total biatch to go through after a long and arduous process of litigation. And in this particular case, we've got Johnny Depp. He's on tour. Does he really want to disrupt tour, the thing that he's been dying to be on for so long, the thing that he testified in court that is his first love is music, right? This is the thing that he wants to be doing even more than acting. He doesn't even really care as much about acting as he does about music. This is what he wants to be doing for the rest of his life, most likely, or at least for a significant portion of the rest of his life. And so why would he want to leave that to come back and get dragged into yet another trial after 6 weeks of trial? Why, right? There's that. There's also the financial expense of trial. Whatever, we don't know how much was paid in that settlement agreement. Most likely there was an amount that was paid, because in order to have a settlement agreement, both sides have to give something or give something up to the other side, right? So it's like, because at the end of the day, a settlement is a contract. It's an agreement between two sides. Both sides are agreeing to either do something or not do something or exchange something. So typically how it works, in my experience, is that the plaintiff says, I agree to withdraw my case, to voluntarily dismiss my own case. And the defense says, all right, I agree to pay you a certain amount of money. And that is perfectly legal. It's perfectly okay. And it's perfectly just a matter of course. So what the amount is, we can't tell by this filing from the court. And most likely we'll never know, because it's another default provision in a settlement agreement is, generally speaking, that there's a confidentiality clause that both sides say that they agree not to talk to anyone about the details of that settlement, other than maybe the fact that it exists, with anyone other than their attorney, maybe their accountant or something, because sometimes there's tax implications. So there are like a very limited number of people with whom they can talk about the details of that settlement agreement, and then that's it. So there's a possibility that something could get leaked, but I would not bank on us ever finding out what that settlement number was. It could be relatively high. It could be $2. Who knows? But my guess is there was some amount of money that is being exchanged for the settlement. But at the same time, I also would reliably guess, maybe is not the right word for it. I would posit that the amount that is being exchanged in the settlement agreement is far less than would be paid to attorneys and in a potential judgment, because there's a whole calculation that goes through here. And to address, Kit Kat says, doesn't that seem like hush money though? To address that, no, it's not. I mean, I understand why people can look at that and say that sounds like hush money, right? Because it sounds like I'm giving you money so that you make the case go away. That is very much what it sounds like. But really what it is the two sides are calculating, number one, how much is it going to cost me to continue this litigation? How much do I have to pay for every single conversation that I have with the attorney, whether it's by phone or by email? They're drafting that email. They're talking to me on the phone. If it's lawyers calculate their fees, assuming that they are billing by the hour, they bill in 6-minute increments. So it's a 0.1 for every 6 minutes, 0.1 of an hour, basically. And so every single phone call, I mean, if different firms have different policies on how they bill, but generally speaking, if you have a phone call that lasts a minute, 2 minutes, that's going to be billed as a 0.1, whether or not that takes a full 6 minutes or not. So there's ways that some attorneys can be very dodgy about the way that they aggregate all of those, but it all adds up. It adds up, whether they're being fishy about it or being very, or whether they're being very above board about the way that they bill. So what they do is the two sides, both sides are doing this. They're calculating how much they're having to pay the attorney, and then how much, like what kind of effort is going to come of actually resolving this case at trial. Number three, what are the facts in my favor? What's the likelihood that I'm actually going to win this thing? So it could very well be that Brooks looked at this and said, you know, there are these other witnesses that are saying that they saw me on set and that things are not the way that I allege. The likelihood of winning might not be as high as what I would like it to be. So there's a risk. How much risk am I comfortable with sitting with? Am I comfortable with maybe a 25% likelihood of winning this case, maybe 50%, maybe 70%? Different people have different comfort levels with varying levels of risk. So that gets calculated in there. Also, because this is talking about an employment kind of situation in an industry that carries cares very much about someone's reputation and getting further work. This could also be a case where that is being factored as well. I mentioned this on Twitter yesterday that for Johnny Depp, the world has heard all of the best and worst that could possibly be heard about him, right? Because we heard all of the bad texts, all of the things that Amber Heard alleged he did, the worst possible things that could be brought out against a person, or I guess specifically against Johnny Depp, have already been brought out, right? Regardless of whether that's true or not, the allegations have been brought out, they've been talked about, they've been alleged, and they've been evaluated. He's going to survive it. He already has survived that case, and arguably with flying colors. So looking at this kind of case here, it could very well be that Brooke's own attorney turned to him and said, hey, look, we just watched the Depp v. Heard trial and the worst came out about him, and he's going to be fine, it looks like. He's going to survive it. So what's going to come out about him here? Not much, especially in comparison to that last trial that is fresh in people's minds. And now on your side, however, you've got people that are alleging that you shouted racist remarks at a homeless woman for what? Like, just to be an a-hole? How is that going to impact your future employability? If that comes out and gets talked about by the media, gets evaluated on social media, and then ultimately a jury looks at and confirms, like if you lose, you could doubly lose by potentially not being able to get hired in this town again. And this is the town to get hired in your industry, right? This is where your industry exists. So that could also be a very strong factor for Brooks. It could be the fact that he's like, if I lose, there's more risk than just the risk of losing and just the loss of this money right here. It's the potential money that I could earn later on down the line and support my family and, do all the other things that I want to do with money and resource, right? So those are all potential factors there. So in my whole TLDR about the settlement is that there are more reasons behind settling than most people often think. And to answer the question from Tim Quazzo, so why settle for JD? He's got reasons to settle too. He's tired, arguably. He's probably exhausted from the Depp v. Heard trial. I do think on some level that he may have been able to render himself relatively litigation proof, at least from nuisance lawsuits like this, if he had actually gone to trial, because then he could have built up a reputation for himself saying, Johnny doesn't settle, right? So that means any other person who wants to just like file a claim against him could then think twice about it, right? Because they could be like, all right, are you sure? Like if I'm the attorney then that gets approached by someone else saying Johnny Depp did this to me, then you could say, like, all right, now, like you're saying this and I'm going to believe you, but tell me the full truth, the whole truth, because if this is something that you are thinking that you can get a quick settlement out of, this is not the kind of guy that does it. You know what I mean? And that may still very well be the case moving forward anyway, because this is like, getting settled at the 11th hour. But generally speaking, it's just the reasons for him to actually settle: stress, money, life. Litigation takes up, it's so much easier to say than to live through. But one of the things, and I talked about this on Twitter too, that one of the things that has always been most stressful for me as a litigator has been not even necessarily the pace of work and deadlines and having to respond to things and fight with people and all this kind of stuff. For me, I think that the part that has been one of the things that I have struggled with more than other things is the fact that it is very emotional, and representing clients, I've found, often carries with it a lot of like, I don't know, like emotional service for your client. I've got a lot of people that come to me with phone calls about panic, especially in when I was an employment litigator, that somebody would call me and talk about like, what if I can't get a job anymore? This has impacted the way that I can make money. How can I pay my bills? When this happened to me, I got fired for the wrong reason. You get people that get very emotional very quickly, and that basically sticks with them through the end of the entire process. And that is so exhausting on your body's resources over time. It can cause all kinds of other problems. It can cause other bad habits. It can cause your relationships around you to fail or to falter. You can get into fights with your spouse. You can get into fights with your parents. You can get into fights with everybody around you. No one, like it could be a situation where like the stress is so much that you don't want to, that like no one around you wants to be around you. You know what I mean? Like this, it can impact your entire life, really, because of the stress that litigation can bring onto you. And that's not even talking about the expense on top of everything else. So for him, he may have just said, you know what? I'm done. I'm done. I just, let's settle it and let's end it. And yeah, be done. And yeah, Kit Kat says, I've been in my own civil legal battle for 3 years with no end in sight. It is incredibly draining. I can vouch for that. Yep. 100%. 100%. That's one of the, and I'm sorry, by the way, that you are dealing with that. It sucks. Those kind of cases were never the ones that I liked, the ones that just kind of hung around for a long time. But yeah, that's an example of what that process can feel like. So anyhow, on that note, I think that it in the end is probably mostly a good thing that it settled. Although, of course, in the court of public opinion, there are those that will say otherwise. There will be those that'll say, oh yes, it was hush hush money. Oh yes, this was somebody that he didn't want these facts to come to light, so he paid them off. You can't assume that. You simply can't assume that. So, okay, let's go through some super chats, shall we? I appreciate all of you guys for super chatting. And first off, Kristen TM, thank you so much for the very generous super chats. It's very appreciative of all you do. As a teacher, I'm so impressed with your ability to clearly explain complex concepts and bring others into the discussion. Thank you. That is very, very kind of you. Sometimes it's easier than other times, but this live stream has been a fun one. So I do very much appreciate it. Austin SA says, because I'll forget, throwing a vote out to cover the Alex Murdaugh case. He'll be charged with murder of wife and son next week. 79 total counts. Oof. Let me write that down. A lot of my focus has been on the occasional Depp v. Heard sort of like universe of facts, but largely getting into the Marilyn Manson cluster of cases. And so expect to see more content from this channel on that particular subject. But I'll look into this. We'll see if maybe this is something that we can look into here as well. Okay. 2012 Jameson says, notice Rottenborn is not signing these. Elaine is. That is an interesting point. He may be saying, look, I don't know if I'm going to get paid for this, so I don't want to put any more work into it. I've seen those memos before saying, look, only put in as much work as is professionally required. And then beyond that, it's a money pit. So that could very well be what's going on there. Lucky says, darn it, I keep missing streams due to work. Good to see you again, Alita. Thank you. Thank you so much. It's good to see you again as well. And I appreciate you being here. I'm sorry you missed it because of work, though, but hopefully you can still catch it on the replay. Alicia Amata says, I wonder if this juror was the one who fell asleep or had spoken out about Amber. Yeah, that would be very curious. I would, and again, I guess I should say again that I would love to talk to any of these jurors if any of them would like to talk to anyone. Once the dust kind of settles, that would be so cool to hear from any of these jurors about their experiences and like see if, what they noticed about the other jurors, what they noticed about themselves, what they were, just observing about the two parties and their attorneys. It would be so interesting, but I don't know. I wonder the same thing as you. It would be interesting if that was the same one that had spoken out or had fallen asleep. Grant McRoberts said, has Amber Heard got another trial? Well, we've got another complaint that has been filed. So it's very early days. I mean, it literally was just filed like 3 days ago, 4 days ago. So I don't know. This might go to trial. Maybe more likely, I don't know. More likely this is something that would likely get resolved pretty quickly. Kiska Hamlin says, so has it been addressed that she shouldn't have won anything because the hoax that was in Adam Waldman's statement was actually true? No, because the jury did go through the verdict form, and they found on that one that the statement was false. So, because the thing about that one is that they said that or not that they said, rather, but the justification for the difference between the three different statements, right? Because the jury found that two of them were not defamatory and one of them was. The one that was the one that was the most specific, talking about that they roughed up the place, well, that they called the cops and then they found that wasn't enough. So then they roughed up the place, called the cops again. But the second time the cops arrived, things were still in order. So he got his ordering wrong in that. And it may have been that the specificity level of that was where the jury said, that's not exactly true. And I think that you were being reckless, So I think I think that there's nothing that's come out since the verdict that says that particular verdict should be overturned. I mean, but then again, I don't know. Maybe Johnny's team is going to come out with some kind of an appeal, and I'll be wrong on that. But there's nothing that has jumped out to me anyway on that. Kiska Hamlin, welcome to being a Bite Club member. I really appreciate having you here. 2012 Jameson says, in a contract, parties can agree to venue. Pro tip. Yep, absolutely. And in fact, it's very common for that to be the case. So this was in the context, he super chatted this in the context of the policy, probably, if I remember correctly, the insurance policy by New York, New York Marine and General Insurance Company. So whether it is an insurance policy or a labor contract or a settlement agreement, it is not uncommon for there to be some kind of a provision in there saying what state's laws or what body of laws govern that particular agreement. So, pro tip, very well taken. Lemon Fresh says, Legalbytes, Elaine said in closing that AH couldn't pay her pledge because of $6 million legal fees. Does this insurance payout mean she lied? So I highlighted this one because this is something that I meant to talk about was the perjury question, right? Because a lot of people have been pointing out on social media that Amber and Elaine both said, yes, the reason why she didn't pay for she didn't pay the ACLU, she didn't pay CHLA, she didn't make those donations or pledges, was because she had all these litigation fees that she had to pay for. She had all these attorney's fees, $5 million, $6 million, whatever, saying that was the reason why, that was a justification why. And so a lot of people are pointing to that and then pointing to this saying, well, she's got this insurer that's paying for it. So that's perjury. Like, she knows that she's not the one paying for it. She knows that this insurance company is. However, if I can play devil's advocate on that one, I think that that probably is not enough for something like perjury because of the fact that there's still a level of uncertainty in that case by New York Marine and General Insurance Company. There's still a little bit of uncertainty there, right? Because they are relying on what the verdict outcome ended up being. So at the time that those statements were made at trial, the verdict had not yet come about, right? Because that was the whole point of the trial, was to end up with the verdict. But in this particular case, with this lawsuit filed by the insurance company against Amber Heard about the indemnity issue, what they're saying is that because the verdict was such as it was, with the fact that they showed, or they decided that she had acted intentionally, that therefore none of her fees are covered by the policy. None of her liability is covered by the policy. And so therefore they shouldn't have to pay it. Their argument relies on the fact that there is a verdict in place at the time that their argument makes sense. Because if that verdict doesn't exist in the way in which it exists right now, they don't necessarily have an argument, right? Because if, let's say, for example, the jury had found all of the elements of defamation except for the intentional ones. They said, no, she acted negligently. Then technically everything else has been met, but it's not defamation. And then she wins and yada, yada. And then she gets everything paid for. But because of the fact that they actually found that these were intentional acts, and that there was actual malice, they've shown that it has been proven that she had acted intentionally, and so therefore she probably isn't entitled to indemnity. So, that basically answers that. I hope that makes it clear enough for you guys. So I think that ultimately what that means is that when it comes to the perjury question, I don't think that there's enough on that. So does it mean that she lied? I don't know. Because, and to sort of nail that down a little bit further, at the time that she made that statement, it may not have been completely clear to them that they were actually going to get those attorney's fees or the liability or whatever paid for by the insurance company. Because it kind of, they may have already known at the time, like, ooh, like this is no surprise to us that we kind of have to win this in order to get everything paid for. Because if we don't win this, we're being sued for defamation by a public figure, which means that that's going to have with it an intentional element. So they may have kind of looked at all those puzzle pieces and said, we are not entirely certain that this insurance company is actually going to come through for us. So we can reliably say, for right now, at this particular moment in time, yes, we are paying for these legal fees. Or yes, Amber Heard is paying for these legal fees. So, but yeah, and I do understand that there is another lawsuit between the two insurance companies as well. I see that in the chat too. Gracefully Insane says, didn't the other insurance company also pay out roughly $5 million at the point last year when they sued the other insurance company? That I have not had a chance to take a look at. So maybe I'll look at that tomorrow, and then have maybe some more nuanced points on this whole insurance issue and perjury issue. But as far as I see it right now, that's how I see it. Jane Smith says, question regarding insurance payments. Since insurance is paying some or all fees in settlement, can they opt to settle with JD for $1, saving them money in the payout, especially since JD said it's not about the money? Well, they could try. However, remember that a settlement is an agreement. So that means it's a contract. So you have to have two sides agreeing to it, which basically means that Johnny Depp also would have to agree to settle. And I'm under the impression that he was never going to settle that particular lawsuit against Amber Heard, because he was going to go all the way to court because he needed to, right? He needed to get his story out, and he's not able to do that if he just settles with Amber Heard. So there's that side, and the insurance company that is paying, assuming that the insurance company is in fact paying for all of Amber Heard's fees, they have no control over Johnny Depp, right? Because he's the opposing party. So they only have maybe some sway with the client that they are paying for. However, at the same time, there's also a very good question about whether or not they would have enough sway to say that, to like, they can't, let me just say this, they can't force Amber to take a settlement agreement either. They can make things very clear that that because of the policy terms, because of XYZ, that they are not going to be paying out more than a certain amount, which could influence her factors in determining whether she should settle or whether she should, continue fighting. But they also can't force her to take a settlement agreement either. So anyway, yeah. Thanks for the question. Kristen is a math nerd, says, from one Millspo to another. Congrats on the wedding. Thank you. And hey, power to the Millspouses, right? It is an enjoyable life, and sometimes it is a bit of a struggle. I know you understand that. But I love it. So far, I love it. It's a fun life, never a dull moment. And yes, I love my man in uniform. Alrighty. I wear t-shirts, says, I wear t-shirts, became a YouTube member. Hey, welcome to Bike Club. That's awesome. I'm glad you're here. Thank you. Patty Joe Sloss sent a $10 super sticker. Thank you. Really kind. And Stephanator says, or Stephanator, I think, says, thank you for all you do and for your Deputy Heard coverage. Your commentary and bites have been life-changing for me, with shark emojis. Thank you. That's really kind of you to say. I really appreciate that. And it's been my pleasure. It's been quite a ride, and I'm very happy to do it. And I'm very happy that I found myself in this line of work. So I'm here for it. And I'm going to be here for a while, and very happy about that. And I hope you guys are too. I hope you guys enjoy the future content that we get coming out there. And Anna3112 says, did you see that Camille was at Johnny's concert in Prague last night? Much love from Italy. Buonasera, Anna. No, I didn't see that, but that's pretty cool. That is pretty cool. I'm sure she enjoyed that. I'm sure he enjoyed having her there. So that's awesome. Much deserved vacation for her after a lot of hard work. So yeah, that's pretty cool. And on the note about the memberships earlier, so I have been, I know for folks that are YouTube members, Patreon members, locals, or Patreon supporters, local supporters, I've been putting a lot of thought into some members only content, members exclusive content, supporter exclusive content. We're probably going to start doing some occasional live streams here and there that are just for folks that are YouTube members and Patreon supporters and local supporters. So I'm figuring out the logistics of how I'm going to put all of that together. So live streams, maybe some other content as well. So if you guys are already members or supporters, thank you guys so much. I know that there hasn't been much out there leading up to this specifically for you guys. I haven't had too much of a chance to do it, but now that I'm starting to get back into the swing of things, it is fully my intention to start rolling out some more exclusive content for you guys. And I really, really appreciate all of your confidence, all of your patience and your kindness in joining the whole channel, joining memberships and all that kind of stuff. So with that, I think that's everything that I wanted to cover on this. This has been delightful. I so appreciate all of you guys being here. This has been wonderful. Thank you so much for hanging around, even with me being primarily absent for the last few weeks. It's been a very eventful few weeks for me personally, and but I'm happy to be back at it. So with that, I missed all of you guys. I missed you. I'm very happy to have you here. With that, we're going to end it for the day and be looking out for some more content on Marilyn Manson and other stuff too. So that's going to be coming out later this week. Okay. And I'll see you guys